Senate Bill 318 is a bill that I introduced with Delegate Lucas. He introduced the same bill on the House side. He and I have been talking about this issue for about 2 years. And basically the problem is you have 451,000 people with felony records in Virginia, probably over 1 million with misdemeanor records. And these folks have a real hard time securing employment. And not necessarily because they're bad people, but a lot of employers feel real uncomfortable hiring somebody with a criminal history because they feel like they might get sued if something happens, or if there's some problem, they get sued for negligent hiring. And so, Delegate Lucas and I have been looking around trying to figure out what to do about this. And this summer, I was at a conference and I became aware that in North Carolina, they adopted some legislation last year premised on the Uniform Collateral Consequences Act, which is a uniform act which was adopted to try and create a process by which people could be relieved of the collateral consequences of their convictions and give employers some sense of a safe harbor in terms of hiring people. And so the way this bill reads, basically anybody who has either 2 felonies out of the same, no more than 2 felonies out of the same act, that's the limit, or 2 misdemeanors, or 1 felony, 1 misdemeanor from separate acts, can file a petition. And it specifically excludes violent felonies and it excludes sex offenses. So you're mainly talking about drug offenses and property crimes, right? And they can file a petition, the Commonwealth Attorney has to file an answer. And in connection with their hearing, they have to prove 4 things. One is that it's been 12 months since they've completed their sentence off probation. 2, that they are engaged in or trying to engage in employment, training, education, rehabilitative program, or something similar to that. 3, no pending felony or misdemeanor charge. 4, that granting the petition would not pose an unreasonable risk to the safety or welfare of the public or the individual. And if they prove that, by preponderance of the evidence, the judge finds that, then the court would issue a certificate restoring or relieving them from the collateral consequences of their conviction, excluding gun rights and voting rights, which are part of in the Constitution. We can't, at least voting rights are, but there's a separate process for restoring gun rights and voting rights. And that's what it would do. And what it does is it says then that the employer, if the employer is ever sued for hiring that person, for saying they should not have hired the person because of their criminal history, they take that certificate. It's presumptively admissible in a civil proceeding to show that they exercise due diligence in hiring the person because the person has been blessed by a court as having been rehabilitated and not a danger to anybody else. And this gives business some certainty in hiring people that they won't get sued, or if they do get sued, they can show people the court blessed this person. It will open up more people to employment. It's something we need to do so that people can get a job. And I think Senator Lucas probably would like to address it as well. She has a lot of personal experience with this.
Senator Lucas.
Yes, so Mr. Chairman of the committee, yes, I do have a lot of personal experience with it. Over the last 18 years, I have found that a lot of folks who may have made a mistake at some point in their lives, who really have rehabilitated themselves and trying to stay gainfully employed, continue to get turned down, not just turned down for employment, but once that criminal history background check is done, then they have to be relieved of employment. I've had to do that for the last 18 years. And I can say it really grieves me because some of these employees have been some of the best employees I have had. They really are trying to make a change in their lives and they work really, really hard at it. They manage to stay employed for maybe 30, 60 days and then their criminal history background check comes back and then it says that you have to relieve them because of the barrier crime. And so for some of these people, just like you said, we understand that there are some cases where that might not be feasible. But it certainly has been the case with me. One case in point, there was a young man who was sentenced to 17 years in prison, and he just turned 40 years old this year. He was in a vehicle with 2 individuals who were having some quarrel with each other. They shot each other. One guy actually died. And the guy who lived went to prison, but then so did the little guy who was sitting in the back seat. And so his probation officer was even working with me to try to see if there was some way that we could keep him employed, and we had to let him go.
Now, I think we all are sympathetic to the goals of the patrons. Let me ask the council, does this accomplish the goals of the patron in a manner that doesn't conflict with or create inconsistencies in the code?
I don't know. That's the problem. I just don't know. it's, for example, on line 72, it says a certificate of relief relieves all collateral sanctions. And then has a variety of exceptions. And quite frankly, I don't know what is meant by collateral sanctions. That's an incredibly broad term. But then it goes on to say that it, on line 74, that it does not automatically relieve a disqualification. And I don't know if collateral sanction and disqualification are meant to be synonymous, or whether those are two different words with different meanings. Look, it may be counsel's own ignorance. I just don't really understand the bill.
Let me ask the patron, I mean, is this the uniform law that's been adopted elsewhere? Has it been drawn to Virginia law? Do we have where's the certificate of relief come from?
The certificate of
Do we have
relief,
any such instrument in Virginia?
no. I can tell the chairman that when I gave direction to staff to draft this, I asked them to base it on the Uniform Act and to do similar to what they did in North Carolina. North Carolina excluded violent felonies and sex offenses. North Carolina, however, gives immunity to employers. I didn't want to go as far as immunity. I just wanted to have a certificate that could be admissible evidence. So that was my direction. I would point out that collateral sanction and disqualification are both defined terms at the very beginning of the bill. It says what they are. And, you know, we can only use language as precise as we can.
All right.
Question for the patient.
Yes, sir.
You said that you said two things that I found a little bit in conflict. On the one hand, you said that you didn't want to give immunity to employers for hiring these folks. And on the other hand, you said that the biggest impediment for these folks is the fact that the employers might get sued for negligent hiring. Why not just give them immunity from, at least not just allow them from being sued based on hiring someone who is a former felon, as you defined in this code section? The negligent hiring can go on for, you can be negligent for other reasons, but you can't be negligent for the fact that you hired somebody who fits your description. Why not do that?
Well, I have a couple of thoughts about that. Number one is, in general, I hate immunity, and I think we give it out down here like chiclets, and so I tend to not support immunity bills. And so that's one reason I didn't put it in. I think immunity tends to be sort of an overly broad concept that can have more unintended consequences than otherwise, and I generally believe in juries and believe in juries' ability to sort things out. So I thought the approach, which I believe was the approach that was in the Collateral, the Uniform Act, which is that the certificate is admissible as evidence that the employer exercised due diligence in hiring, was the better approach than the North Carolina approach, which was the immunity. That's my first response. My second response to that is, this doesn't expunge the charge, it doesn't get rid of it, and the fact that a person has a felony conviction is admissible as to their credibility, and so the jury's going to hear about it anyway. And so, I'm not. That's what. There's other reasons why that comes into evidence. So, and that's why I went with that approach. If the jury's going to hear about it anyway, at least to give the certificate to them to show them that the court's looked at it and said they're a good person and they're rehabilitated, instead of just not having a certificate at all that the jury gets to consider.
Mr. Chairman, he's a good young lawyer and he convinced me.
Mr. Chairman, Senator Lucas I've known Senator Surovell for probably longer than Senator Lucas has, and he didn't convince me. So I would move to, even though this is a laudable purpose, I don't know that the words get there, and I move to gently pass this by.
Mr. Chairman, moved and seconded, passed to aye. All in favor, signify by saying aye. Aye. All opposed?
No.
Vote your noes, please. And I do think that this deserves more attention, and
opposed to the concept, but pulling the model back, I think creates an awful lot of problems. I think this needs some work over the next year. We'd be more than happy to.
Well, I can't promise you that I'll be here another 25 years, but I know I'll be here for.
All right. You're next, Bill, Senator Surovell.
393.
393.
Mr. Chairman, 393 is a bill that was brought to my attention by one of the judges in Fairfax County. And it relates to protective orders. And basically, the problem that's arisen is, I don't know how it works in your jurisdictions, but in terms of my personal experience, most of the time when a protective order is issued, in Northern Virginia at least, it comes with an affidavit signed by the petitioner stating what the underlying facts are as to what led to the protective order being issued. And so you have that affidavit that's sitting there in the file. And so you know why the judge issued the protective order. Recently, however, at least in Fairfax County Juvenile Court, the judges started doing more ex parte hearings instead of using affidavits. The code does allow you, instead of using affidavit, to actually take testimony from the protective order, the person seeking the protective order. And if the person does it that way, if it doesn't get an affidavit, then the person accused of the protective order doesn't have any idea what the basis was for the issuance of the protective order. And there's actually it's a disconnect in the code, because if you look at protective orders under 16.1253, which is PPOs for children, if it's done in an ex parte hearing, the judge is required to state what the basis was for issuing the order when they issue the order. So you have some notice of what the facts were as to why the order was issued. But when it's an adult, in an ex parte hearing, they're not required to state the basis for their ruling, why the protective order was issued. And so all my bill does is it makes the two statutes consistent. It says that when a protective order is issued under 16.1-253 on the family protective order, if it's done ex parte, the judge has to state the basis, the factual basis for issuing the order, so that when the accused person gets the thing delivered to them, they can see what the factual allegations are. So not showing up at the hearing completely guessing what happened, or things has to get continued when they finally find out what happened in court or whatever. It's designed to make the two consistent and provide notice. That's the concept.
Senator Surovell, there's still a petition filed, isn't it?
There's a petition filed, but you don't have to state the factual basis of the petition, provide an affidavit if you do it in the next part of the hearing, part of the petition.
Any questions of the patron on this? Just, Senator McDougal.
Is the wording under the exact same as what we use now?
Yes, identical.
Any other questions of the patron? Senator Surovell, anybody told you maybe this is too much work for them or anything like that with regard to the district judges? I'm just curious.
Nobody's approached me and had an issue with this.
Okay. Above reports. Is anybody, well, just hold on 1 second. Is there anyone who'd like to speak for it? No one. Anyone who'd like to speak against it? No one. Okay. Bill's before us.
Second.
Motion properly before us. All in favor, please say aye.
Aye.
Opposed, no. Ayes have it. That one. Report, Senator Surovell.
Thank you, Mr. Chairman. The next one I have is 534. This one's going to take a few minutes. 534 is a bill you all saw last year. What it is, it's a bill to attempt to preserve the value of an expungement in the Commonwealth of Virginia. Again, last year you saw this. I'm sorry, this is a substitute, Mr. Chairman. If we could distribute that and
Yes, we distribute substitute. Thank you.
and
Can I get a motion on the substitute? Motion properly before us. All in favor, please say aye. Aye. Opposed, no. The substitute is before us, Senator Surovell.
you all might remember this from last year because it was Delegate Lucassi's bill, but whenever we presented it, he brought me along as his counsel to explain it. And so I was here before you last year with Delegate Lucas explaining this bill. And when we presented last time, it had a First Amendment issue, which I think I've resolved. We'll get to that in a second. Just so the committee has some context here. In Virginia, you can only get an expungement if you're not guilty or charged as flat out dismissed without any finding if you're guilty. You can't stipulate you're guilty and get an expungement. You have to be completely innocent. It's the only time you get an expungement in Virginia is completely innocent or a governor's pardon. Unless Senator McDougal's bill passes.
It is addressing the issues for juveniles. So.
Right. So until before the internet, expungements were good because when an expungement happens, the record disappears. You can't see that anybody's ever charged with anything. But now the internet's out there, there's a lot of companies that have decided to take this information and then republish it, provide private criminal background check services. And because of the proliferation of this, Congress made sure that the Fair Credit Reporting Act applied to criminal background checks, okay? And the way the Fair Credit Reporting Act works is that if somebody pulls somebody's criminal history for purposes of their eligibility for something, like a job, an insurance policy, a mortgage, if it's for an eligibility for some benefit, then it falls under the Fair Credit Reporting Act. And the Fair Credit Reporting Act says that if you're going to provide this information, you have to have processes in place to maintain accuracy. It has a really heightened burden when it comes to public records, but it uses effectively a negligence standard. It does not require actual notice. It says that if you're going to put out information about people, if you have to have processes in place to make sure it's accurate. That's how the Fair Credit Reporting Act works. So today, for a record pull that's done for purposes of employment, or for purposes of a mortgage, or purposes of insurance, the entities that you're going to hear from in a second can be sued if they publish information about a Virginia expungement. If they have an expunged charge that's on their record, they can be sued for it, and they pay judgments on it, and they have been sued repeatedly for it. Okay? What this bill seeks to address is that sometimes people pull records for other purposes besides employment or eligibility for something. And there are a whole bunch of companies, dozens and dozens and dozens of companies, that provide these background polls for reasons that are not covered by the Fair Credit Reporting Act. And they are continuing to publish information about people's expunged charges. And right now, there's no way to hold them accountable because it's not defamation, because it's truthful information, and because statutorily, nobody's said that it's damaging in the code, and Congress hasn't expanded the Fair Credit Act to cover that. So you have companies like LexisNexis. If you go on this website, Intellius.com, backgroundcheck.com, instantcheckmate.com, checkpeople.com, places like that, you can pull these records. This morning I went on BeenVerified.com. And you look at the bottom of BeenVerified.com's website, it says, we're not a consumer reporting agency as defined by the Fair Credit Reporting Act because the information we've provided is not collected or provided in whole for the purposes of furnishing a consumer report for the purposes I described earlier. So all these companies are putting out this information that we have said shouldn't be out there, and they can't be held liable for it. And so basically what this statute says is that if anybody creates a consumer report about with a listing of criminal charges for a commercial purpose, being paid money, and that information and that record contains inaccuracies, and somebody's damaged, they can bring a lawsuit for $500 of statutory damages or actual damages, whichever are greater, and attorney's fees. That's basically what it says. And it makes clear that we're not talking about law enforcement agencies, we're not talking about suing courts or anything else. We're talking about companies that provide these records. And you're going to hear in a second, these companies want to have actual notice. They want somebody to tell them that something's been expunged before they can be sued.
Senator Surovell.
Yes, sir.
Before we get to that, I've got a question. Is the substitutes you drafted a constitutional?
Yes, I believe it is.
Can I ask Mr. Benjamin about that?
Mr. Chairman, I can't tell you that it is constitutional. At this point, I have concerns that it is unconstitutional.
I think most of us understand and are sympathetic to what he's trying to do here because we want an expungement to be worth something. Can you make any suggestions that may help the patron with regard to the potential for being unconstitutional?
I can help. My suggestion would be a much more simplistic approach that would deal directly with expungement and that would provide the clarity of certain notice. And so, for example, and to preface my approach, I'll tell you, you'll see in the bill before you, there's a number of definitions. But what they all get to is the provision of what's on line 24, criminal history record information as defined in Title IX. You'll also see that the substitute before you is limited to people who provide this information for commercial purpose. That being the case, it didn't appear necessary, in my mind, to have all the different exceptions that you have. Further, my concern was that those exceptions meant that the bill was not speaker neutral. Instead, it made certain speaker-based distinctions, which I understand to be a First Amendment red flag. So I approached it as directly as I could, trying to achieve the laudable goal that the patron has. And so one approach would be as follows. Any person or entity regularly engaged in the business of disseminating or publishing criminal history record information as defined in 9.01-101, who disseminates or publishes such information, knowing it to have been expunged, or after having received notice of the issuance of a court order of expungement, shall be liable to the subject of the criminal history record information for actual damages. I would then have a subsection B, similar to what's in the bill before you, saying no person shall be liable under this section if the dissemination or publication of such information was not prohibited at the time of the dissemination or publication, or if the dissemination is otherwise required by law.
Senator Surovell, what do you think of that? And I guess another question would be, did everybody on the committee get that language? Do you need to hear it again? Can you do it again, please, Mr. Lincoln?
There would be two subsections, and the operative section is A, and is directed at expungement, and it provides notice to the provider. It says, any person or entity regularly engaged in the business of disseminating or publishing criminal history record information as defined in 9.01-101, who disseminates or publishes such information knowing it to have been expunged, or after having received notice of the issuance of a court order of expungement, shall be liable to the subject of the criminal history record information for actual damages. So the liability attaches if the person who publishes that information knows that it was expunged, or they've received a court order of expungement.
Senator McDougal.
Logistically, under that language, an individual, there's no list that's published of expungement. So the way it would logistically come about is somebody would get one of these background checks and say, I'm not doing X, Y, Z, hiring you, working with you, whatever, and the person would probably find out that way. And then the individual would be able to go to the provider and say, this was expunged, you have to take it off, and then if they don't at that point, then they would be liable.
Right.
So, Mr. Chairman,
Senator
so
McDougal.
that version moves the ball down the field farther than where we are today under the law, but probably not where the patron intended it to be, which is he wanted, in essence, treat the state police or to publish an order or list of expungements. So this is kind of putting the baby in the pool.
The substitute that's before you doesn't require the state police to do anything. That would be an interesting approach. And it does not go as far as the patron intends. I adopted this method because it's simple and because it can be further worked with over the years to achieve a better and broader effect. The goal is absolutely pure, but the First Amendment issues are pervasive. That's the problem. Because what you're talking about is prohibiting somebody from doing something with accurate information lawfully obtained. And even though it's information, it's still considered speech. And even though you're being paid to publish it, it still has First Amendment protections. And so trying to prohibit the publication of accurate, lawfully obtained information is problematic.
Senator Surovell, what's your reaction to that?
A couple things. First of all, I think if the committee were to go in this direction, it needs statutory damages or actual damages, whichever is greater, because it's often hard to define actual damages in these situations.
Maybe I should ask it this way. If there was a chance this bill was going to pass and that was the language that was going to pass, how would you feel about it?
I'm happy to get something done finally, but I, with all respect, don't agree with Mr. Benjamin's First Amendment analysis. And I have two cases, but I haven't had a chance to talk to him about it at length. But
So would you consider it a friendly amendment if somebody adopted that language or not?
I guess so. I would like to have a discussion about the
Is there a motion on the language that Mr. Benjamin has just given us? So to amend. Is there a second to that? Motion properly before us to amend it as Mr. Benjamin described. All in favor, please say aye. Aye. Opposed, no. That amendment is now before us. Would you like to speak to that anymore, or can we let some folks come up and talk about it?
I think they're happy now the way it's written.
Well, let's hear from them. Is there any opposition that remains to this as a result of the language that you just heard?
Mr. Chairman, Fred Helm, on behalf of the Consumer Industry Association, that is a major improvement. Our concern all along has been notice, those that are in the business in other states doing there's an expungement. They get notice, they get a paper record, and it's accurate. And there are, I'll remind you that you are overlaying, if you pass the bill, a separate state cause of action on top of the already existing federal obligations. So it is a separate layering on top of what's already a federally regulated arena.
But all this is saying is, if you give actual notice or you know about it, and they tell you to take it off, you either have to take it off or you're going to be liable for actual damage.
That's right.
Are you support or oppose that?
No, well, we support that.
Okay.
We've asked for that all along. In fact, the bill that came over last year had a notice provision on it.
Mr. Chairman, what is the federal,
Senator Edwards.
what's the federal overlay you mentioned?
It's the Fair Credit Reporting Act, but we are preempted from enacting anything that overlays that. We're specifically preempted under federal law from doing that. So I think phrasing it that way is a little inaccurate legally, but this is not covered by that.
This is a state cause of action. Come on up.
Mr. Chairman, members of the committee, I'm Chris White with the Vector Corporation here on behalf of LexisNexis. I guess the notice revision certainly is helpful and improves the bill 100%. But the question I had was, in the amended substitute, did we discuss, or is there a time period from the time at which an entity like Lexis or one of the credit bureaus gets notice to where we have the time? Originally in the substitute, I think it was 60 days. Is that still the case?
There is no time. When there's notice, Mr. Chairman, I think that's fair, and I would move that amendment. It gives them a 60-day period within which to update their database.
Mr. Chairman, I think it would read, who disseminates or publishes such information within 60 days of knowing it to have been expunged.
No. Within 60 days?
After 60 days. After 60 days, or 60 days after. We can insert the concept.
All right, is that a motion, Senator Overton?
Mr. Chairman,
A second to that?
I have a question. Knowing is subjective. How about after it's been given notice, which would be objective, I think. Would that be better? Counsel. And directed to counsel.
Mr. Chairman. If I could, we have our expert here, if I could, Mr. Chairman. It might be able to address some of these issues on dates and whether a good idea to have a hard set time. Derek Hellman with the Consumer Debt Industry Association.
Let me ask counsel this. A knowledge requirement, knowing, that's the objective. Reasonably should know is the subjective, correct? Reasonably should know is the objective. A reasonable person would know, that's the subjective standard. And knowing is the objective. Knowing is subjective. Knowing is they either know or they don't know.
Mr. Chairman, if you say having been given notice, I mean, maybe they got it in the mail and threw it away. But the fact they got it in the mail is notice. That's why I'm saying after notice.
All right, there is currently a motion to, whatever Mr. Benjamin's language was, to give them 60 days to cleanse that reporting after they have notice that it's been expired, correct? That's my motion. Is there a second to that? Motion properly before to amend it as described. All in favor, please say aye. Aye. Opposed, no. Vote your no. Mr. Chairman, that is amended further. Senator Overcheck.
All I would say is, I think that there are a lot of problems. I think Senator Edwards is right. I think if there are questions about how the notice is to be communicated, and how do you prove it, this makes it a lot better, but I still think it's unworkable. And it can't possibly function. And with that, Mr. Chairman, I would move to pass the bill by indefinitely.
Is there a second to that? Is there a second to that? Pass the bill by? That motion fails for lack of a second.
Recommend bill be reported.
Senator Norman seconds it. By proxy.
All right, so we have a motion to pass the bill by, evidently properly seconded by the gentleman who's not here. Is there a substitute motion? I'm sorry, Senator Lucas.
Yes, sir, Mr. Chairman, I move that, I recommend bill be reported. As amended, yes.
All right, there's a substitute motion properly before us to report the bill as amended multiple times. All in favor, please say aye.
Aye.
Opposed, no.
No.
Should I call the roll? You need to vote no? Please call the roll.
Senator Sasloff,
2, 4, 5.
Senator Norman,
No.
Senator Howell, Senator Lucas,
Aye.
Senator Edwards, Senator McDougal, Senator McEachin,
Aye.
Senator Stewart, Senator Stanley, Senator Reeves, Senator Garrett, Senator Chapin, Senator Deeds,
Yes.
Senator Surovell, Senator Overton. 8 ayes, 7 nays.
Your report.
Yes, sir. Last one. 572. 572 is a simple little bill. Instead of reversing the Supreme Court, we're reversing the Court of Appeals.
Is this your case?
No. I did have a case where this affected me about 10 years ago, but.
That's okay.
Yeah. But basically, for those of you that practice traffic law, when somebody's charged with reckless driving, under 46-869, the court, if they find that the degree of culpability is slight, the court may reduce the charge of improper driving. And this gets into that issue we had last week, because the statute uses the word court. The Court of Appeals said that only a judge could reduce it to improper, but not a jury. And I think a jury ought to have the ability to make a reckless charge improper if a judge does. I don't see why, if you choose to have a jury trial on reckless, you waive the right to have an improper. I mean, that's effectively what this means. Just to give you all an example, I had a case 10 years ago. I had a client who was, he was driving his friend to the airport, it was late, and there was a police officer shooting LiDAR, and jumped out on the road and tried to stop him in the middle of the highway and ended up being struck. And they charged my client with reckless driving. He never saw this police officer because there was cars in front of him. And when my focus group said, when I told them improper, they're like, that's exactly what it is. The police officer shouldn't have been around the road, and your client was speeding, and so it's just. Yeah.
Anybody have a problem with this?
I think all attorneys are
Can I ask,
different.
Mr. Chair, can I ask a question? Wouldn't you, a defendant be entitled to an instruction on
Yeah.
improper?
Right, that's what it does.
Well, isn't that already, is that?
They don't, the Court of Appeals has held you do not get instruction on improper because we use the word court and not court or jury in the statute.
Anybody wish to speak in opposition to this? State police care about this? Commonwealth attorneys? Sheriffs? Anybody? All right, bill's before us. Moved and seconded, the bill be reported. All in favor, signify by saying aye. All opposed. That bill is reported.
Appreciate the committee's indulgence, thank you.
All right, thank you very much.